Hi everyone. Today we are going to discuss about professional ethics and bar bench relationship. So, introduction. Administration of justice is one of the main functions of the state. Administration of justice is considered to be a joint concern, effort and responsibility of both the bench and bar. The bench and the bar can be considered to be two wheels of a chariot of goddess of justice, that is Themis. The main functions of the bar or legal profession is to aid in the administration of justice. The role played by the advocates or legal practitioners in the administration of justice has gained the legal profession esteem and respect in the society. In order to maintain the confidence, esteem, and respect of the society, one who enters the legal profession is to be guided by morality, ethics, and rules of discipline. In India, the law relating to the legal practitioners or advocates is contained in the Advocates Act 1961 and the rules made thereunder. The Act and the rules made thereunder deal with rights, duties, and liabilities of advocates. The Act provides for the establishment of state bar councils, the Bar Council of India, and various committees for regulating the enrollment, conduct, and discipline of advocates. The Act also deals with various other functions and powers of state bar councils, the Bar Council of India, and various committees. The State Bar Councils. By Section 3 of the Advocates Act 1961, there shall be a Bar Council of each state. The Bar Council for State of Kerala is known as the Bar Council of Kerala. A State Bar Council shall consist of the following members. 1. The Advocates General of the State ex officio. That is, the first one is the Advocate General of the State ex officio, and second, the elected members from among the advocates on the state roll. If the electorate, that is the total number of advocates enrolled in the State Bar Council, does not exceed 5,000, 15 members shall be elected to the State Bar Council. If the electorate exceeds 5,000 and does not exceed 10,000, 20 members shall be elected to the State Bar Council. If the electorate exceeds 10,000, 25 members shall be elected to the State Bar Council. One half of the elected members shall be persons who have for at least 10 years been advocates on a state roll. There shall be a chairman and a vice chairman for each State Bar Council. The chairman and vice chairman is to be elected by the Bar Council. The term of office of an elected member of a State Bar Council shall be 5 years from the date of publication of the result. The State Bar Council shall be a body corporate, having perpetual succession and a common seal. It shall have power to acquire and hold property. It can enter into contract, it can sue and be sued in its name. Section 6 of the Act provides functions of State Bar Council. The following are the functions of State Bar Council. 1. To admit persons as advocates on its roll. Then second, to prepare and maintain such roll. Third, to entertain and determine cases of misconduct against advocates on its roll. Fourth, to safeguard the rights, privileges, and interests of advocates on its roll. Fifth, to promote the growth of bar association for the purpose of effective implementation of welfare schemes. Sixth, to promote and support law reforms. Seventh, to conduct seminars and organize talks on legal topic by eminent jurists and publish journals and papers of legal interest. Eighth, to organize legal aid to the poor. And ninth, to manage and invest the funds of the Bar Council. 10th, to visit and inspect universities in accordance with the directions of Bar Council of India. Now, the Bar Council of India. Section 4 of the Advocates Act 1961 provides for the constitution of Bar Council of India. The Bar Council of India shall consist of the following members. 1. The Attorney General of India ex officio. 2. The Solicitor General of India ex officio. 3. Elected members from the State Bar Council each state bar council elects one member from among its members to the Bar Council of India. There shall be a chairman and vice chairman for the Bar Council of India. The chairman and vice chairman is elected by the members of the Bar Council of India from among its members. The Bar Council of India shall be a body corporate having perpetual succession and a common seal. It shall have power to acquire and hold property. It can enter into contract. It can sue and be sued in its name. The following are the functions of the Bar Council of India. A. To lay down standards of professional conduct and etiquette for advocates. B. To lay down the procedure to be followed by its disciplinary committee and the disciplinary committee of each state bar council. C. To safeguard the rights, privileges and interests of advocates. D. To promote and support law reform. E. To exercise general supervision and control over state bar councils. F. To promote legal education and to lay down standards of legal education. G. To recognize universities whose degree in law shall be a qualification for enrollment as an advocate. H. To conduct seminars and organize talks on legal topics and eminent jurists and publish journals and papers of legal interest. I. To organize legal aid to the poor. J. To recognize on a reciprocal basis foreign qualification in law obtained outside India for the purpose of admission as an advocate. K. To manage and invest the funds of the Bar Council of India. Now, Disciplinary Committee. Section 9 of the Advocates Act 1961 provides for the constitution of Disciplinary Committee. The Bar Council of India and State Bar Council shall constitute one or more disciplinary committee. Each disciplinary committee shall consist of 3 persons. Out of 3 members, 2 persons shall be elected by the Bar Council and an advocate who is qualified to be elected to the State Bar Council. The senior-most advocate from amongst the members of a disciplinary committee shall be the chairman of the committee. The disciplinary committee shall deal with complaints of professional misconduct against advocates. Now, Legal Aid Committee. A bar council may constitute one or more legal aid committees. Each legal aid committee shall consist of prescribed number of members. The number of members shall not be less than 9 and more than 9. And next is Standing Committee. A state bar council shall constitute the following standing committees. The first one is Executive Committee. It shall consist of 5 members elected by the council from amongst its members. And the second one is Enrollment Committee. It shall consist of 3 members elected by the council from amongst its members. Now, the Bar Council of India shall constitute the following standing committees. That is the Executive Committee and Legal Education Committee. Executive Committee, it shall consist of 9 members elected by the council from amongst its members. And Legal Education Committee, it shall consist of 10 members, of whom 5 shall be persons elected by the council from amongst its members, and 5 shall be persons co-opted by the council who are not members of the council. Now, who is an advocate, or what are the qualifications and disqualifications for admission as an advocate? By virtue of Section 3 of the Act, a bar council is to be constituted in every state. By virtue of Section 6 and 17 of the Act, the State Bar Council has to prepare and maintain a roll of advocates and admit persons as advocates on its roll. An advocate is a person whose name is entered in any roll maintained by the State Bar Council. Section 24 of the Advocates Act prescribes the qualification for admission as advocates. So, the qualifications is given in Section 24. A person is qualified to be admitted as an advocate on a state roll if he fulfills the following condition. First one, he should be a citizen of India. Second, he should have completed the age of 21 years. Third, he should have obtained a degree in law from any university in India which is recognized by Bar Council of India. And the fourth one, he should have paid the enrollment fee. So section 24 capital A of Advocates Act prescribes disqualifications for enrollment. Section 24 prescribes qualifications for enrollment, and section 24 capital A of the Advocates Act prescribes disqualifications for enrollment. Under the following conditions, a person shall not be admitted as an advocate on a state roll. A. If he is convicted of an offence involving moral turpitude, the disqualification shall cease to have effect after a period of 2 years has elapsed since his release. Now B. If he is convicted of an offence under the provision of Untouchability Offences Act 1955, the disqualification shall cease to have effect after a period of 2 years has elapsed since his release. And C. If he is dismissed or removed from employment or office under the state on any charge involving moral turpitude, the expression state shall have the same meaning assigned to it under Article 12 of the Constitution of India. The disqualification shall cease to have effect after a period of 2 years has elapsed since his dismissal or removal. So the state shall have the same meaning, the expression state shall have the same meaning as in Article 12 of the Constitution of India. A person who is found guilty and dealt with under the provisions of the Probation of Offenders Act 1958 is not qualified person for enrollment as an advocate. So these are the four kinds of disqualifications discussed under section 24 capital A. Now, Haniraj Chulani versus Bar Council of Maharashtra and Goa, 1996. Haniraj Chulani versus Bar Council of Maharashtra and Goa, 1996. It was held that a practicing medical practitioner, though obtained the degree of law, cannot be permitted to be enrolled as an advocate. A person cannot be permitted to carry on other profession simultaneously with the legal profession. By virtue of section 22 of Advocates Act, a certificate of enrollment is to be issued by the State Bar Council to every person whose name is entered in the roll of advocates. An advocate shall notify any change in the place of residence to the State Bar Council within 90 days of such change. Now, who is a senior advocate? By virtue of Section 16 of Advocates Act 1961, advocates can be classified into two groups. They are senior advocates and other advocates. The status of senior advocate will be conferred by the Supreme Court or High Court. The rules regarding designation as senior advocate by Supreme Court is contained in Order 4, Rule 2 of Supreme Court Rules 1966. Order 4, Rule 2 of the Supreme Court Rules 1966. The Chief Justice of India and the judges of the Supreme Court may, with the consent of the advocate, designate an advocate as senior advocate if in their opinion he is deserving such distinction. It is conferred on the basis of his merits such as ability, standing at the bar, special knowledge and experience in law. When an advocate is designated as a senior advocate by the Supreme Court, the registrar shall communicate to all the high courts and the secretary to the Bar Council of India and the secretary of the Bar Council concerned the name of the said advocate and the date on which he was so designated. The rules regarding designation as senior advocate by the Kerala High Court is framed by the High Court of Kerala. The following are the main rules. The High Court of Kerala may designate an advocate as senior advocate if in their opinion, by virtue of his ability, standing at the bar or special knowledge or experience in law, the said advocate is deserving such a distinction. The designation shall be made either on an application from the advocate concerned or suo motu. If designation is proposed to be made suo motu, the consent of the advocate concerned shall be taken before such designation. The proposal for designation, either on application by the advocate or suo motu, shall be considered at the meeting of the Chief Justice and other judges of the High Court. Such proposal shall be considered as accepted only if not less than 2/3 of the total number of judges present at such meeting are in favor of accepting the application. When an advocate is designated as a senior advocate, the registrar shall communicate the fact to the registrar. The fact shall be communicated to the registrar, Supreme Court and the Bar Council of Kerala, the Bar Council of India and Bar Councils of other states, and also to all the district and session judges subordinate to the High Court. By virtue of Section 17 of the Advocates Act 1961, every state bar council shall prepare and maintain a roll of advocates of all persons who are admitted to be advocates on the roll of the state bar council. The roll of advocates shall be maintained in two parts. The first part containing the names and address of the senior advocates, and the second part containing the name and address of other advocates in order of their seniority. A senior advocate shall not file a wakalatnama or file an appearance or a pleading or application in any court or tribunal in India. He shall not appear without an advocate on record in the Supreme Court or without a junior advocate in any other court or tribunal in India. He shall not accept instructions to draw pleadings or affidavits, advise on evidence, or do any drafting work of an analogous kind in any court or tribunal in India, or undertake convincing work of any kind whatsoever. He can settle the pleadings. Now, restriction on practice. Chapter 1, Part 6 of the Bar Council of India rules provides for the restrictions on senior advocates in the matter of their practice of the profession of law. Senior advocates shall, in the matter of their practice of the profession of law mentioned in Section 30 of the Act, be subject to the following restriction. A. A senior advocate shall not file a wakalatnama or act in any court or tribunal or before any person or other authority mentioned in Section 30 of the Act. Now the explanation. To act means to file an appearance or any pleading or application in any court or tribunal or before any person or other authority mentioned in Section 30 of the Act, or to do any act other than pleading required or authorized by law to be done by a party in such court or tribunal or before any person or other authorities mentioned in the said section, that is Section 30, either in person or by his recognized agent or by an advocate or an attorney on his behalf. Now B subclause 1. A senior advocate shall not appear without an advocate on record in the Supreme Court or without an advocate in Part 2 of the state roll in any court or tribunal or before any person or other authorities mentioned in Section 30 of the Act. And B subclause 2. Where a senior advocate has been engaged prior to the coming into force of the rules in this chapter, he shall not continue thereafter unless an advocate in Part 2 of the state roll is engaged along with him, provided that a senior advocate may continue to appear without an advocate in Part 2 of the state roll in cases which he had been briefed to appear for the prosecution or defense in a criminal case, if he was so briefed before he is designated as senior advocate or before coming into operation of the rules of this chapter, as the case may be. Now C. He shall not accept instructions to draft pleadings or affidavits, advise on evidence, or to do any drafting work of an analogous kind in any court or tribunal or before any person or other authorities mentioned in section 30 of the Act, or undertake convincing work of any kind whatsoever. The restriction, however, shall not extend to settling any such matter as aforesaid in consultation with an advocate in Part 2 of the State Roll. Now, subclause C. A senior advocate shall, however, be free to make concession or give undertaking in the course of argument on behalf of his client on instruction from their junior advocate. Now, D. He shall not accept directly from a client any brief or instruction to appear in any court or tribunal or before any person or other authorities in India. Now, E. A senior advocate who had acted as an advocate in a case shall not, after he has been designated as a senior advocate, advise on the grounds of appeal in a court of appeal or in the Supreme Court except with an advocate as aforesaid. F. A senior advocate may, in recognition of the service rendered by an advocate in Part 2 of the State Roll, appearing in any matter, pay him a fee which he considers reasonable. Now, advocate on record. In exercise of powers conferred by Article 145 of Indian Constitution, the Supreme Court of India has made the Supreme Court Rules 1966. The Supreme Court Rules 1966 provides for the conditions of practice of advocates in the Supreme Court. The Supreme Court Rules provides that an advocate on record only shall have a right to file an appearance or act for a party in the Supreme Court. An advocate on record can appear and plead in any matter before the Supreme Court. A senior advocate or any other advocate shall not appear and plead in any matter unless he is instructed by an advocate on record. An advocate other than a senior advocate can register in the Supreme Court as an advocate on record. The following are the qualifications for registering as an advocate on record. 1. He should undergo training for 1 year with an advocate on record approved by the Supreme Court. 2. His name should be borne on the roll of the State Bar Council for a period of not less than 3 years on the commencement of training. 3. He should pass the test conducted by the court. 4. He should have an office in Delhi within a radius of 16 kilometers from the courthouse. 5. He should give an undertaking to employ a registered clerk within 1 month of the registration as an advocate on record. 6. He should pay the registration fee. Now, what are the rights and privileges of a lawyer? The following are the rights and privileges of a lawyer. 1. Right to pre-audience. The right of pre-audience means right of a lawyer at bar to be heard before another. Section 23 of the Advocates Act governs the right of pre-audience in the following order. First, Attorney General of India, then Solicitor General of India, then Additional Solicitor General of India, then the Second Additional Solicitor General of India, then Advocate General of State. Among Advocate Generals inter se, the right is determined by their seniority. And then comes Senior Advocates, and among Senior Advocates inter se, the right is determined by their seniority. And then comes the Other Advocates, and among Other Advocates inter se, the right is determined by their seniority. And the second right is right to practice. By virtue of Section 29 of the Act, advocates are the only class of persons entitled to practice the profession of law. By virtue of Section 33 of the Act, a person shall not be entitled to practice in any court or before any authority or person unless he is enrolled as an advocate under the Act. By virtue of Section 45 of the Act, if a person who is not entitled to practice in any court or before any authority or person practices in any court or before any authority or person, he shall be punishable with imprisonment for a term which may extend to 6 months. By virtue of Section 30 of the Advocates Act, an advocate whose name is entered in the state roll shall be entitled as of right to practice throughout India in all courts, including the Supreme Court. An advocate shall be entitled to practice before any tribunal or person legally authorized to take evidence. An advocate shall be entitled to practice before any other authority or person before whom such advocate is by or under any law for the time being in force entitled to practice. In Saji CP versus Union of India and others 2011, Saji CP versus Union of India and others 2011, it was held that by virtue of Section 30 of Advocates Act 1961, parties can engage a lawyer of his choice, and lawyers are entitled to file wakalat before all courts or tribunals and such other forum in India as a matter of right. Permission of court or tribunal need not be obtained to engage a lawyer. By virtue of Section 32 of Advocates Act, any court, authority or person may permit any person not enrolled as an advocate to appear before it or him in any particular case. So this is an exception where the advocates are the exclusive class who can practice. So by virtue of Section 32 of Advocates Act, any court, authority or person may permit any person not enrolled as an advocate to appear before it or him in any particular case. In Harishankar Rastogi versus Girigari Sharma, Harishankar Rastogi versus Girigari Sharma 1978, the Supreme Court held that anyone who is not an advocate cannot, as of right, appear in the court and claim to plead for another. So Section 32 of Advocates, it's a discretion of the court or the authority or the person. So it was emphasized in Harishankar Rastogi versus Girigari Sharma 1978, where the Supreme Court held that anyone who is not an advocate cannot, as of right, appear in the court and claim to plead for another. It is open to a person who is a party to a proceeding to apply to the court to permit a non-advocate to appear and argue for him. The court may grant or withhold permission to appear and plead in a given case. The power of the court cannot be exercised in routine. It is open to the court to grant or withhold permission. The court may even, after grant of permission, withdraw it halfway through if representative proves himself to be reprehensible. Now, in PC Jose versus Nandakumar, the Kerala High Court held that if an advocate himself is a litigant and appears as a litigant in person, he must not address the court from the advocate's table or in the robes of advocate. He has to address the court from the place and in the same way as an ordinary member of the public. So that was held in PC Jose versus Nandakumar 1997, and the decision was by Kerala High Court. Further, it was held that when members of the bar are to stand inside a courtroom due to lack of seating facilities, members of the public, even if they are litigants in the same court, cannot claim any right to occupy the seating facilities available inside the court. It is open to the presiding officer to direct such persons to vacate for the accommodating members of the bar if there is no other seating facility available. Major K. Matthews versus Registrar General, High Court of Judicature at Madras. Major K. Matthews versus Registrar General, High Court of Judicature at Madras, 2003. Major K. Matthews has approached the Madras High Court to issue a writ of declaration declaring that an ordinary member of the public like him who is conducting a case party in person in a civil or criminal court is entitled to be seated in the court and to make use of the table available in the courtroom, and such liberties should not be interfered with or questioned by members of the bar. The court held that the litigants or parties appearing in person before courts for their own cause cannot claim the same privileges or rights being given to the members of the bar or advocates, and they cannot occupy or use the chairs and tables provided for the advocates. However, they are entitled to be provided with a convenient place to address the court and highlight their cause. No one is entitled to prevent or obstruct the litigants or parties appearing in person. Now, standards of professional conduct and etiquette. An advocate is an officer of court. He is a privileged member of the community. An advocate is given the exclusive right to practice the profession of law. An advocate who enjoys several rights and privileges under the statute should not be free from any duty. There should be a code of conduct for regulating the behavior of a practicing lawyer towards himself, his client, his adversary, and towards the court. Professional ethics may be defined as code of conduct, written or unwritten, for regulating the behavior of a practicing lawyer towards himself, his client, his opponent, his colleague, and towards the public and the court. The main object of the professional ethics is to maintain the dignity of the legal profession and the friendly relation between the bench and bar. Section 49, subclause 1, subclause C of the Advocates Act 1961 empowers the Bar Council of India to make rules to prescribe standards of professional conduct and etiquette to be observed by advocates. In exercise of the powers conferred under Section 49, subclause 1, subclause C of Advocates Act, the Bar Council of India has framed the following canons of conduct and etiquette. So the first canon is duty to the court. The following are the duties of an advocate towards the court. Here, A. While presenting his case and acting before a court, an advocate shall conduct himself with dignity and self-respect. He shall not be servile or too ready to obey others, lacking independence. Whenever there is a proper ground for serious complaint against a judicial officer, he has a right and duty to submit his grievance to proper authorities. And B. An advocate shall maintain towards the court a respectful attitude, bearing in mind that the dignity of the judicial office is essential for the survival of a free community. C. An advocate shall not influence the decision of a court by any illegal or improper means. He shall not make any private communication with a judge relating to a pending case. B. An advocate shall use his best effort to restrain and prevent his client from resorting to sharp or unfair practices or from doing anything in relation to the court, opposing counsel or parties. An advocate shall refuse to represent the client who persists in such improper conduct. He shall not consider himself a merry mouthpiece of the client. He shall avoid the scurrilous, that is abusive and insulting attacks in the pleadings. He shall avoid showing lack of self-control and language during the argument in the court. E. An advocate shall appear in court at all times only in prescribed dress, and his appearance shall always be presentable. F. An advocate shall not practice before a judge sitting alone or bench of judge if the judge or any member of the bench is related to the advocate as husband, father, grandfather, son, grandson, brother, father-in-law, son-in-law, brother-in-law, uncle, nephew, first cousin, wife, mother, daughter, sister, mother-in-law, daughter-in-law, sister-in-law, aunt or niece. So that is, there should not be any relation between the judge and the advocate. G. An advocate shall not wear bands or gowns in the public places other than in courts except on such ceremonial occasions. H. An advocate shall not appear in any court or before any tribunal or any other authority for or against an organization or an institution, society, or corporation if he is a member of the executive committee of such organization or institution or society or corporation. Executive committee means a committee or body of persons vested with general management of the affairs of the organization, institution, society, or corporation. Now, I. An advocate should not act or plead in any matter which he himself has a pecuniary interest. Now, J. An advocate shall not stand as a surety or certify the soundness of a surety if his client required for the purpose of any legal proceeding. So that is with the first canon, that is duty towards the court, and the second canon of conduct is duty to the client. The following are the duties of an advocate towards his client. A. An advocate is bound to accept any brief in the court or tribunal or any authority or before which he professes to practice at a free fee consistent with his standing at the bar and the nature of the case. However, in special circumstances, he can reject a brief. It may be possible for him to reject a brief in the following cases. The first one, if he is physically disabled from appearing for the client. 2. If he is not available to present the case in the court. 3. If his training in a special branch limits his usefulness in other branches. 4. If the client is not prepared and able to pay him his reasonable fee. 5th, if he confines his practice in some courts and in some places only. 6. If he is likely to be called as a witness in the same case. 7. If he already been consulted by other side. Now, in Muhammad Rafi A.S. versus State of Tamil Nadu and others, 2011, after a clash between policemen and lawyers, Bar Association passed a resolution that no one will defend policemen in criminal cases. The Supreme Court held that such a resolution is wholly illegal and null and void, as it is against all traditions of bar and professional ethics. Now B, that is the second duty towards the client. An advocate shall not ordinarily withdraw from engagement once accepted without sufficient cause and reasonable notice given to the client. In B.L. Vadera vs. State, NCT Delhi, 2000, the Delhi High Court issued the following declaration and directions. First, lawyers have no right to strike. Strike by lawyers is illegal and unethical. Second, if on the ground of strike a lawyer abstains from appearing in the court in a case in which he holds the wakalat for the client, he is committing a professional misconduct and a breach of contract, a breach of trust, and a breach of professional duty. Third, if in the name of the strike anyone obstructs or prevents a lawyer from discharging his professional duty of appearing in the court, he is committing a criminal offense and is interfering with the administration of justice and is committing a contempt of court. In Raman Service Private Limited versus Subhash Kapoor. In Raman Services Private Limited versus Subhash Kapoor, 2001, the Supreme Court held that when a court passes an ex parte decree due to the absence of an advocate in pursuance of a strike and subsequently the ex parte decree is set aside on the condition of payment of cost, the party is entitled to realize the amount of cost from the concerned advocate. If the litigant suffers entirely on the account of his advocate's non-appearance in the court, he has the remedy to sue the advocate for damages. In Kokanda B and others versus KD Ganapati and others, 2011, Now, the Supreme Court held that an advocate cannot ordinarily withdraw the engagement without sufficient cause and without giving reasonable and sufficient notice to the client. Now, C, that is the third duty, an advocate should not accept a brief or appear in a case in which he has reason to believe that he will be a witness. If he has already been engaged in a case in which he will be a witness on a material question of fact, he should not continue to appear as an advocate if he can retire without jeopardizing his client's interest. Now, D, an advocate shall make a full and frank disclosure to his client relating to his connection with the parties and any interest which is likely to affect the client's judgment in engaging him or continuing the engagement. E, an advocate shall fearlessly uphold the interest of his client by all fair and honorable means. He shall defend a person accused of a crime regardless of his personal opinion as to the guilt of the accused. He should keep in mind that his loyalty is to the law, which requires that no man should be convicted without adequate evidence. Now, F, an advocate appearing for the prosecution in a criminal trial shall so conduct the prosecution that it does not lead to conviction of the innocent. The suppression of materials capable of establishing the innocence of the accused shall be avoided. G, an advocate shall not act on the instruction of any person other than his client or authorized agent. H, an advocate shall not stipulate for a fee contingent on the results of litigation or agree to share the proceeds thereof. An advocate shall not bid for or purchase any property sold in the execution of a decree or order in any suit in which he was in any way professionally engaged. J, an advocate shall not adjust fees payable to him by his client against his own personal liability to the client. K, an advocate shall not do anything whereby the abuse or takes advantage of the confidence reposed in him by his client. In Kokanda B. Pundacha and others versus K.D. Ganapathy and others, 2011, the Supreme Court held that a lawyer cannot pass on the confidential information to anyone, as the client entrusts the whole obligation of handling legal proceedings to an advocate. He has to, accordingly to the principles of uberrima fits, that is, the utmost good faith, integrity, fairness, and loyalty. Now, L, an advocate should keep accounts of the client's money entrusted to him. A copy of the client's account shall be furnished to him on demand. The client should pay the necessary copying charge. M, if an advocate receives an amount on behalf of his client, the fact of such receipt must be intimated to the client as early as possible. In Bar Council of AP versus Kurapati Satyanarayana, 2003, a suit was filed by one GN before the additional district, additional district municip through the respondent's advocate. The suit having been declared, execution petition was filed for realization for the decretal amount. The respondent was engaged as a counsel for GN in the execution proceeding as well. The respondent received a total sum of 14,600 on various dates in the execution of proceeding, but he did not make payment of the same to GN. Thereupon, GN filed a complaint on 18/10/1996 before additional district municip. The complaint, along with the reply filed by the respondent and the connected records, were forwarded to the State Bar Council. After inquiry, the State Bar Council awarded the punishment of removal of his name from the roll of the Bar Council. Thereupon, the respondent preferred an appeal to the Bar Council of India. The Bar Council of India was of the view that the respondent has utilized the money for his own treatment under compelling circumstance and that he had no intention to misappropriate the decretal amount. The State Bar Council preferred an appeal against the order of the Disciplinary Committee of the Bar Council of India. The Supreme Court allowed the appeal and confirmed the decision of the State Bar Council to remove the name of the respondent. The Supreme Court held that amongst the various types of misconduct envisaged of a legal practitioner, the misappropriation of the client's money must be regarded as one of the gravest. Having regard to the serious nature of the misconduct of the punishment of removal of his name from the roll of the Bar Council would be the only appropriate punishment. Now, N. An advocate shall not divert any portion of the money entrusted to him for the expense towards his fees without consent in writing of the client. O. After termination of the proceeding, the advocate shall be at liberty to appropriate towards the settled or legal fees due to him any sum remaining unexpended out of the money paid to him for expense or any amount that has come into his hand in that proceeding. In Adi Saxena versus Balram Prasad Sharma 2000, the Supreme Court held that the advocate has no lien on the files entrusted to him by the client for the unpaid balance fees. If the client does not want to continue the engagement of a particular advocate, he should return the brief to the client. The refusal of return of the files to the client when he demanded the same would amount to misconduct, and such advocate is liable to punished for such misconduct. An advocate has the right to sue his client for his fees if not paid, like any other profession. Now, P. An advocate shall not lend money to his client for the purpose of any action of legal proceeding in which he is engaged by such client. And Q. An advocate who has advised in connection with the institution of a suit, appeal, or other matter, or has drawn pleadings or acted for a party shall not appear or plead for the opposite party. So that is with the duty to the client. And the next canon, third canon, is duty to opponent. An advocate has the following duties to opponent. 1. An advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. 2. An advocate shall do his best to carry out legitimate promises made to the opposite party, even though not reduced to writing or enforceable under the rules of the court. 3rd, an advocate shall not use unfair and malicious tactics, methods, or device against the opponents. 4. He shall not abuse the rules of evidence and the processes of the court in order to injure the opponent or benefit himself. 5. He shall not make such allegation which he does not intend to support by evidence. 6. He must not deliberately convey the judge information not admissible in evidence. 7. He must not make needless attacks on the reputation of the opponent or his witness or otherwise harass them. When they are in the witness box, the advocate shall not make it an opportunity to gratify the anger or malice of his client. 8. An advocate may take concessions to the convenience of the opponent and his lawyer. An advocate shall not take advantage of the error that can be cured. And the 4th canon is duty to colleagues. The following are the duties of an advocate to colleagues. 1. An advocate shall not solicit work or advertise by circulars, advertisement, thoughts, personal communication, or interviews. He shall not solicit work and advertise by procuring his photograph to the published in connection with the cases in which he has been engaged. His signboard or nameplate should be of reasonable size. The signboard or nameplate of stationery should not indicate that he is president or member of a bar council or any association, or that he specializes in any particular type of work, or that he was a judge or an advocate general. A tout means a person who procures in consideration of any remuneration moving from any advocate the employment of such advocate in any legal business. An advocate shall not engage torts to obtain cases. Engaging torts and payment of commission to torts to procure clients is violation of professional etiquette. Now, 2nd, an advocate shall not accept a fee less than the fee taxable under the rules when the client is able to pay the same. 3rd, an advocate shall not enter appearance in any case in which there is already an advocate on record except with his consent. Now, the 5th canon is duty in imparting training. An advocate shall not demand or accept fees for or any premium from any person as a consideration of imparting training in law under the rules prescribed by a state bar council to enable such person to qualify for enrollment under the Advocates Act 1961. Senior lawyers have the duty to impart all necessary training to the junior members in the profession. The juniors can come up only with the proper direction, training, and help of the seniors. The professional prestige can be perpetuated only through the juniors in the bar. Therefore, the senior lawyers should impart necessary training to the junior members of the profession. In Ramohan versus Jayakrishnan, that is 1981, the Kerala High Court observed, the bench and the senior advocates owe duty to the juniors in the bar. They should be given all encouragements. They are, in fact, a trust in the hands of the seniors. A junior is often elated, very happy or proud when he files a joint wakalat with the senior. He gets justifiable satisfaction when his name appears in the law reports with his senior. Encouragement to the juniors by allowing them to handle cases will, to a large extent, help courts to cut down pendency of cases. Most of the juniors are competent and will prove their mettle if opportunities are given. That will help to mold their career and creation of an effective sound line of offense and defense in the bar. A good senior is the best elevator of a junior. The bar without seniors is like cricket without wicket. Seniors should lead by examples. And now the sixth canon is duty not to engage in any other business and restriction on other employments. The first one, an advocate shall not personally engage in any business. He may be a sleeping partner in a firm doing business, provided that, in the opinion of the State Bar Council, the nature of the business is not inconsistent with the profession. In Bhupendra Kumar Sharma versus Bar Association Pathankot, the appellant, a handicapped person, was found to be running his three business, a PCO, both a photocopying center and a firm dealing with coal briquettes, after his enrollment as advocate, and thus guilty of professional misconduct. Now, in Madhav M. Bhokarikar versus Ganesh M. Bhokarikar, that 2004. Here, a practicing lawyer secured dealership of retail petrol pump on complaint received from the respondent accusing the appellant of having taken dealership of a retail outlet of petroleum product. The disciplinary proceedings were initiated against the appellant by the State Bar Council. On inquiry, disciplinary committee of the State Bar Council found the charge proved. During the pendency of the inquiry against him, he entered into a partnership with a younger brother and agreed to be a sleeping partner. Now, the second one, an advocate may be a director or chairman of a board of directors of a company with or without any ordinary sitting fee, provided none of his duties are of an executive character. An advocate shall not be a managing director or a secretary of any company. Now, third one, an advocate shall not be a full-time salaried employee of any person, firm, corporation or concern. If he takes up any such employment, he shall intimate the fact to the Bar Council, on whose roll his name appears, and shall cease to practice as an advocate as long as he continues in such employment. The fourth one, an advocate who has inherited or succeeded a family business may continue it, but may not personally participate in the management of that business. The fifth one, an advocate may review parliamentary bill for a remuneration, edit legal textbook at a salary, do press vetting for newspaper, coach pupils for legal examination, set and examine question papers. He may engage in broadcasting, journalism, lecturing and teaching subjects, legal and non-legal, without offending the rules regarding the advertisement and full-time employment. Now, the seventh canon is duty to the public. The welfare of the society demands protection of the law of the land. The lawyers are looked upon as protectors, preservers, saviors and ministers of justice. The nature of the duties discharged by an advocate is in the nature of a public duty. The legal profession is a profession of great honor. It has been created not for private gain but for public good. It is not a money-making occupation but a branch of administration of justice. Lawyers help in finding out the truth of disputes between the contesting litigants. Lawyers have a duty to render their service available to the public generally without any discrimination. They must be ready and willing to render legal aid to the poor and also in matters involving public interest. So that is the end of this session. This is part 1. We will be having furthermore parts in this regard, that is ethics. Now, thank you for listening. Thank you for your support. Like, comment and subscribe. Click that bell icon so that you get an update when I upload my next video or a podcast. Thank you.